All rise. Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Thomas D. Savaga, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Morning. Welcome to this session of oral argument of the 5th District Court of Appeals. It's our pleasure to preside over the cases on the docket this morning. Let me introduce the panel to you. To my right is Judge Alan Lawson, and to my left is Judge Brian Lambert, who is the newest member of our court, but will not be junior member for too much longer because we have a new judge that will be appointed shortly to fill the newly created 11th position on our court. We have 3 cases on the docket this morning. One is a criminal case. That case will be allotted 15 minutes per side. The civil cases will be allotted 20 minutes per side. If the appellant wishes to reserve any time for rebuttal, let me know. We have a clock on the podium that will assist you in keeping time. If you have any electronic devices that may go off during the course of oral argument, please turn them off so that we're not interrupted. And so with that, we'll take the cases in the order as listed on the docket. We have 2 cases where oral argument was dispensed with, and that's Lanier versus SunTrust and Baslieres versus Rodriguez. So if anybody is here for those 2 cases, the oral argument has been dispensed with. So we'll begin with the first case on the docket, Woods versus State.
May it please the court. I'm Chris Quarles. I represent Luther Woods in this direct appeal from his conviction for armed robbery, grand theft, and resulting 25-year sentence. The key issue at trial was the identification of the bank robber. He wore a mask which covered most of his face. The teller who testified...
I'll tell you what was confusing to me in the way you chose to brief this case, and maybe you can clear it up for me, is you have one issue on appeal that relates to the admission of evidence, but then you have a subheading and spend a substantial amount of time discussing and sort of relying upon the statement and the remark that the prosecutor made in closing argument where he said the word officer. And that was not objected to, correct?
Correct, but...
What is the standard of review for an unobjected to comment by a prosecutor in closing argument?
I only put that in because the fear of his first trial, Mr. Wood's first trial, ended in a hung jury. Prior to the second trial, the defense filed a motion limine to prevent the testimony of Kevin Krause because they were afraid that the jury would, first of all, they said his testimony was irrelevant, which it was. Number 2, they were afraid that it would come to light that the jury would put 2 and 2 together and conclude that Mr. Krause was in fact law enforcement, and that's how his relationship with Mr. Woods, that was a relationship, and they would presume that the jury would draw a bad conclusion from that he was in fact a criminal.
Well, again, does the reason why you put it in your brief change the standard of review for an unobjected to comment in closing argument?
I didn't raise the mention of officer in the closing argument as a separate point. I just
right, and that's what's confusing, because that would be a fundamental error standard.
No, I'm not arguing that should be the reason for the retrial.
Well, then what relevance does it have to the issue? Because at the time that the trial judge admitted the evidence that you said should not have been admitted, he didn't know that comment was going to be made, right?
No, but...
So if we look at trial judge error there, what relevance is that comment unless you analyze it separately under a fundamental...
It's relevant only to support the conclusion that the jury probably concluded that Mr. Krause was in fact law enforcement. That's all. That's all. Now, what relevance was Mr. Krause?
But still, I mean, wouldn't that, if you're going to rely on that...
I'm not relying on that, Your Honor.
Okay, so we can just ignore that.
Sure, absolutely. That's just a little ammunition.
Get to your main point then. Go ahead.
Okay. Officer Krause, who was Mr. Woods' federal probation officer who had never met him prior to the robbery, he, in fact, met him for the first time the afternoon of the robbery, and he noticed Mr. Woods has apparently a goatee, and so did the bank robber. And that was, the mask covered down to his lip, the teller said she could see from his lip down, and what she noticed was the unusual facial hair, specifically the goatee. Well, Mr. Krause, Officer Krause, went out and met Mr. Woods for the first time, and he testified that he went back to the office after he met him for the first time, and he was online looking at the Sentinel, and he sees a still from the surveillance camera of a bank robbery, and he says, "Oh my God, that guy's got a goatee." He black African-American male with a goatee. He said, "That looks like Luther Woods." So he called the Orlando Police Department, and that's why they pulled Mr. Woods over and arrested him on an unrelated warrant, and then it all went from there. Well, the state's theory of admissibility was Officer Krause's testimony was important because it showed why the investigation focused on Mr. Woods initially. That's not relevant to prove any element of the crime. And number two,
Is that your strongest argument?
absolutely. It's completely irrelevant, and undoubtedly the jury concluded that, in fact, Kevin Krause's relationship with Woods arose from his law enforcement capacity.
How would they know that?
Well,
How would you know that that's what they concluded?
well, as the motion limine said, he came into drove into Mr. Woods' neighborhood. He saw a group of black males standing out in the area of the yard of Mr. Woods' address. He didn't know which one was Mr. Woods, so he yelled out his car window, "Luther Woods!" And I'm sure everybody looked up startled, because somebody driving into that neighborhood and yelling out somebody's name, you never know what's going on. And he came over to the car and talked to him briefly. He testified that he looked shocked or nervous when he called out his name, but I think anybody in that neighborhood who sees some strange man driving the neighborhood and just yell out the car window a name, they're going to be nervous.
Let me just quote from, I think it's Hardy. We reject appellant's speculation that despite the restrictions on the testimony of these witnesses, the jury obviously knew who and what they were. To do otherwise would impose a per se prohibition on testimony by police and parole officers on the conjecture that all such personnel fit some readily discernible personality profile. And I'm just struggling to see how, under the facts of this case, it would be anything other than a per se rule to say that this testimony couldn't come in because the jury might figure out from the circumstances and the fact that he drove in at a certain time and didn't have any other reason to be there that this guy might be law enforcement related. I mean, that...
Well, that's why I threw in the stray remark on closing argument where the prosecutor messed up and first referred to him as
legally irrelevant remark, I think.
Yes,
right?
yes. But Kevin Krause's testimony was completely irrelevant. I mean, it also, as they said in closing argument, the state said, summing up the evidence, you have the teller's ID, you have Mr. Krause's identification.
How close to the time of the crime did Mr. Krause pull into the driveway and see Mr. Woods?
3 hours.
Okay. And it wasn't his testimony that he appeared to be, I mean, he in appearance and dress and everything matched the description of the person in close in time. I mean, his appearance was...
Only the facial hair, that was it. Black male with a goatee.
What if Mr. Krause worked at the 7-Eleven and had seen Luther before and saw him 3 hours after this crime, and then he reads the Orlando Sentinel and says, "Hey, I recognize that's Luther. He comes to the store, and let me call the police. I think I know who we're talking about."
If he had prior knowledge of Mr. Woods, like in your example, Mr. Krause, Officer Krause, had no prior knowledge of Mr. Woods before he saw him.
A lot of prior knowledge. I mean, he saw him, and then he saw the...
One time, yes. It's sort of like transference. You see somebody a half an hour late with a goatee, a black male with a goatee, and you could go back and you look online and you see a black male wearing a mask down here with a black goatee. It's transference. You see, oh, that looks like that, just like that guy I saw. I mean, it's easily done. It's a psychological phenomenon. Well, if there are no further questions, I'll save the rest for the bonus.
May it please the court, I'm Rebecca Wall, Assistant Attorney General representing the state in this appeal. We all know why law enforcement puts out to the media photos, surveillance photos, security photos, descriptions of vehicles and suspects. It's so the public will see that, and if they see anything that might be helpful, they'll call in a lead to the police, and that's exactly what happened here. Mr. Kraus did nothing more than if it had been, Judge Lambert mentioned the 7-Eleven clerk. Let's say it was the mailman who had never seen the defendant before. It delivers mail, sees the defendant outside his house, thinks that he looks familiar or similar to the photo, calls the police and gives them a lead. That's exactly what Mr. Kraus did.
Did Mr. Kraus also testify that when he pulled up 3 hours after the crime that he saw a vehicle in front of the house that matched the description of the...
No, his testimony was that a few days before he had gone to the house, the defendant hadn't been there, but he did see a vehicle that matched the description, or he didn't say that matched the description. He just saw,
described it.
he saw a vehicle,
Matched the description.
right, and described the vehicle he saw. It just so happened that there was other evidence that that was a vehicle that was supposed to be linked to the, or thought to be linked. So his testimony was just like any other citizen who had seen photos in the media and thought they might have a lead for the police and called it in. It's important to recognize that what Mr. Kraus testified to was not an identification of the defendant at trial. He only testified that he gave the police what he thought might be a lead. He didn't identify the defendant, he just gave them a name. The defendant took that, put together a photo lineup and other things. So this wasn't at all like a police officer coming into court, looking at a video and telling the jury that's the defendant. In this case, the main witness was the teller, who actually saw the defendant before he came into the bank, watched him pull the mask over his face, so she had a look at his whole body, his whole face before the mask was pulled on, and interacted with him the whole time. And I think it's also interesting if you look at Mr. Kraus's testimony, when he describes how the defendant came over and talked to him through the passenger window that he had put down. The way he describes it is he actually was, it looked like he was looking at the exact part of the defendant's face that the security video showed. He was leaning in the passenger window, and he was able to focus on that lower part of the defendant's face, just like the security photo showed. What he did was nothing more than any citizen would have or could have done to give a lead to the police, and his testimony was relevant and admissible. Even if the court, for whatever reason, finds that it shouldn't have been admitted, it clearly was harmless, because the unequivocal testimony of Ruby Toledo, her out-of-court identification unequivocal, her in-court identification, and the jury had the actual photos to look at, compare, and make their own assessment. This was not at all of the police officer testifying and usurping the jury's territory. It was relevant, it was admissible. The one slip of the tongue in closing argument was absolutely not objected to, was not fundamental, was not error. Based on all the evidence and these arguments, the state asked the court to affirm.
Okay, thank you.
As far as it being whether or not it was another identification, like the teller, in closing argument, the state told the jury, you should look at the lineup that the teller did, the circumstances surrounding the photographic lineup, her in-court ID, the identification by Mr. Kraus. So they did try to bolster the identification. As far as the evidence and whether it's harmless, Ruby Toledo, the teller, she testified that at the photo array, she said she picked out Mr. Woods' photo, said she was pretty certain. At trial, she said still very certain. There were no latent fingerprints. There's no forensic evidence tying Mr. Woods at all. They couldn't link the money that was found at his house to the bank. They had a partial boot print or shoe print on the counter, and they said could be it. They couldn't tell size. They couldn't tell pattern. There were no distinguishing identification marks on that partial shoe print. There were some cell phone records that he'd made a phone call in that general geographic area that morning. That's it. It wasn't overwhelming evidence by any means. Thank you.
Okay, thank you.